Thank you everyone for coming. I told Bob that he shouldn't take it personal that we have such a slim crowd. It's not him. And on that note, Judge Delano apologizes. She's not going to be able to make it today. They have a judges meeting at noon now, so I guess she's going to video conference in. But so she's not going to join us. Before I introduce our speaker, though, I wanted to make a couple announcements. Earlier today, I circulated a copy of Administrative Order 2015-9. It relates to relief from the discharge injunction to allow a debtor to modify an unreaffirmed debt that's secured by a lien on the homestead. So I don't know if, I guess they were having problems where debtors were moving to reopen courts to get relief from the discharge injunction to allow them to do a mortgage modification. And this is sort of like a comfort order to allow them to do that. So if you have any clients that have received a discharge and they want to modify their loan, that's what they need to give the bank. Two other announcements. Next meeting is December 17th, same time, same place. We'll have Lara Fernandez of Trenum Law in Tampa. She's going to provide us a case law update focusing on 11th Circuit decisions. So, and then you'll want to note your calendar for February 25th. Chief Judge Williamson is continuing Judge Genovese's practice of giving a state of the district address, and he's going to give it at our meeting on that date, February 25th. So hopefully, I'll need to hire people from the street maybe, fill the room. All right. Without further ado, I want to introduce our speaker today. His name is Robert Elgidely, and he's a shareholder with the law firm of Genovese, Joblove, and Battista in Fort Lauderdale. I say in Fort Lauderdale, but I think Bob is practicing more in Tampa and Fort Myers these days than anywhere. I run into him on the streets in Tampa, and when I don't, he tells me he's there. He just got back. Bob focuses his practice in bankruptcy, and for the last several years he's been primarily representing trustees and fiduciaries in cases stemming from mass fraud. He has an incredible resume. He's originally from the New York area, and he's admitted in all the districts in New York, the District of Florida, the districts of Florida, the 11th Circuit. He's a great asset to our bar. Certainly I've worked with him before. He is a passionate advocate and a good friend. So, Robert Elka.
Thank you. Thank you, Mr. Rivera, for the kind words. I'll make sure I make a deposit in my account so the check clears this afternoon. And I want to thank you all for the privilege of presenting today. I've been, as Luis said, I've been appearing here in several matters for the past, I'd say, 9 years, and it's been a privilege to work with everybody in this community, and the bench is great as well, so thank you all. The topic today is the amendments to the Federal Rules of Civil Procedure that will be effective on December 1st. So today's, November 19th, and in a couple of weeks we'll have a revamped rules of procedure. And we'll also be discussing their impact in bankruptcy proceedings. Now, the rules are the product of a very lengthy process and spirited debates over an extended period of time. And quite honestly, I did not appreciate all that goes into proposing new rules of procedure until I was preparing for this presentation. Originally, in 2010, the Civil Rules Committee convened at Duke Law School to discuss proposed amendments to the Rules of Civil Procedure. They convened along with 200 judges, practitioners, and academics. They then agreed on a set of proposed rules and first published those proposed amendments in August 2013. The proposed amendments were then the subject of 2,300 written comments to the amendments. I don't know who took the time to actually comment on these proposed amendments, but obviously people that were very passionate about the subject matter. They were then the subject of 3 public hearings, which involved 120 witnesses. It's absolutely amazing. Ultimately, they were approved by the Supreme Court and then transmitted to Congress on April 29, 2015, this year. The rules will become effective on December 1st unless Congress takes action, which, as we all know, to get Congress to do anything, it's highly, highly unlikely. What are the goals of the rules? There are numerous goals, but in a nutshell, to put it in a nutshell, they have the objective of securing the just, speedy, and inexpensive determination of every action. Certainly, you want justice, and you want to endeavor into a search for the truth, and you do not want somebody raising an amendment to the rule of procedure and say you can't get that document or you can't depose that witness because of some technical reason in the rules of procedure. You want to be able to continue to get the evidence you need to prove your case or to defend a case, notwithstanding any technicalities. Apparently, despite a decrease in bankruptcy filings, there's still an issue with languishing cases and heavy court dockets. So the rules are also intended to speed the progress of cases through the judicial system and to make it less costly for all of the parties. Why are the rules relevant to bankruptcy practitioners, the rules of civil procedure? Well, as we know, the rules of civil procedure are largely incorporated into the federal rules of bankruptcy procedure, specifically Rule 7026, 7030, 7031, 7033, 7034. All of the primary rules of civil procedure are incorporated word for word into the federal rules of bankruptcy procedure. They're also incorporated as it relates to contested matters pursuant to Bankruptcy Rule 9014. So it's critically important that we are familiar with the amendments to the rules of civil procedure and that we take them into account as well as the local rules of the court and any administrative orders that have been issued by the court. I know you're all familiar with the administrative order prescribing procedures for adversary proceedings that Judge Genovese put in place in late 2014. That administrative order applies to cases that were filed after February 1st, 2015. And it's an excellent document. I mean, it establishes a great process, great protocol to streamline litigation. I'm going to go directly to what I consider the heart of the changes to the rules of procedure, because I think it does somewhat result in a sea change for discovery in adversary proceedings in bankruptcy cases. It's the change to Rule 26B1, which relates to the scope of discovery and the limits on discovery in lawsuits. The rule now reads that the scope of discovery is anything that's relevant to a party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. If these factors sound familiar to you, they should be, because they existed in the rules of procedure before the rules were amended, but they were in a different section of Rule 26. They were in the section relating to parties filing motions seeking protective orders from onerous discovery or the court limiting discovery. The drafters or the rule committee determined it was appropriate to take them from that section and put them directly in the scope of discovery to tighten up the scope and to make it more explicit to parties as to what is discoverable and what is not discoverable. Many of you know the phrase reasonably calculated to lead to the discovery of admissible evidence. And that was in the prior It's in the current Rule 26, but won't be effective after December 1st. Why is that important? It's important because a lot of parties were using that phrase, reasonably calculated to lead to the discovery of admissible evidence, as a way to get documents or deposition testimony that might sort of lead to something that might sort of kind of be relevant in the future. And I'm guilty of that, to be quite frank with you. I've done that many times. In fact, recently I had a case in front of Judge Delano where the defendant submitted something in camera to the judge, and she ruled in court that it's not relevant. And I said to myself, she ruled against me. And I thought to myself, well, it's reasonably calculated to lead to the discovery of admissible evidence. It could have some value, Judge. Of course, I didn't say that out loud. I accepted the ruling with a smile on my face, and it was the right ruling, quite honestly, particularly if you look at the changes to the rules of procedure. The proportionality standard is very, very significant. In looking at these factors one by one, it's number one, the importance of the issues at stake in the action. Well, I think we're all going to pretty much agree that if we're the plaintiff, we're going to think the issues at stake in the litigation are pretty important. It's going to be interesting to see how that develops through the case law after December 1st, 2015. Certainly a defendant's going to say that, going to have a position, or a third party, quite honestly, could take the position that it has nothing to do with this case. You're seeking discovery for some improper purpose that has nothing to do with this lawsuit. So that's factor number one, and they specifically ordered the factors in the manner in which they deemed to be most important. The second factor is the amount in controversy. I also think this is an interesting factor because I have cases actually throughout the country. I don't know if Luis said that I'm also licensed in New York, where I regularly practice as well, and I had a case recently in Virginia. And depending upon the jurisdiction you're in, and Mr. McHale will attest to this too, the amount of damages varies widely in the court's opinion. The case I had in Virginia was over $1.2 million. A fraudulent transfer is $1.2 million. And earlier this year, there was a published opinion out of that case, and the judge went on and on about the astonishing amount of damages, the $1.2 million in damages. I got to tell you, if that case is in the Middle District of Florida or Southern Florida, that's going to be, might as well just be county court or small claims court, because the amount of controversy, and quite honestly, if you have a motion to compel in that case in Virginia versus a motion to compel in the case here, and you're looking at that factor, certainly the judge is going to view it differently, just based upon the types of claims that are live in the jurisdiction. The third factor, the party's relative access to the relevant information. And I find this factor interesting as well. Maybe I should have submitted comments to the rules because I'm so excited by them. But there's, you look at certain cases. You look at cases where there's an elderly debtor. We've had several of those cases where an elderly debtor, and they have this stock answer that I don't have a computer, I don't know how to turn it on, and, I don't know anything about it. And, does that mean that you just take that at face value? I mean, what if that debtor went to MIT and has a forensic computer degree or something of that effect? I mean, is there going to be now discovery into the party's relative access to relevant information? The rules talk about that as being discovery on discovery. I find it interesting because, as Mr. Rivera said, I regularly represent trustees, and as we know, when cases are filed, trustees are third-party outsiders to the relationship and transactions between the parties pre-petition. And an article that I came across talks about this criteria, the standard, as addressing the information asymmetry, where one party may have very little discoverable information while the other party may have substantial information. And the note to the amended rule says that in practice, these circumstances often mean that the burden of responding to discovery lies heavier on the party who has more information, and properly so. So, as when you represent a receiver or a trustee or some other party that has very limited access to information, I think you could argue and refer the court to the note in support of the rules as to why you need the information and why it is proportional to the needs of the case. The other factor is the party's resources. Is the party a corporation? Is it a closely held corporation? Is it a publicly traded corporation? You know, all of these factors are going to be fact intensive, quite honestly. So, just make sure I don't miss any here. Oh, the last one, it's a pretty important one. Whether the burden or expense of the proposed discovery outweighs its likely benefit. And we all know that sort of that language from another section of Rule 26 is a undue burden or expense. The Rule Committee decided to put that into the scope of discovery, and again, to attain the objective of securing the just, speedy, and inexpensive determination of every action. It's a significant change to the rules, and one of the reasons that the rules were changed so substantially is because of the exponential increase in electronic discovery and electronic documents. And they were trying to rein back this abundant data that existed. I came across this cartoon which I thought was funny. I wish I had extra copies, I could pass it around, but I'll step out here. Maybe I should step over here. It talks about proportionality, and it has a picture of a judge looking at a lawyer handing her a piece of paper, and then there's looks like the defendant sitting at the table, and the judge says, "What's this?" And the lawyer says, "It's a motion to produce the defendant's entire ESI and infrastructure, Your Honor." And the defendant says, "Fine, I'll pay the expletive parking ticket." So I think that this cartoon really sums up that, you know, and again, I've been guilty of this. I mean, I've been guilty of Mr. Leisure and Mr. Johnson. They represent a debtor, and I'm asking for emails for the 4-year period prior to the bankruptcy filing. I'm not saying there's anything wrong with that. I'm just saying that was a joke, Jeff. I'm saying that it needs to be proportional to the needs of the case, and this is going to be very fertile ground for motion practice, and it's going to be very contentious as to what's proportional and what's not. The Rules Committee made it very clear, though, that the burden is not on the requesting party to establish that their requests are proportional. You just need to, in framing your discovery request, consider what is proportional, knowing that the receiving party is going to be looking at what's proportional to the needs of the case, and ultimately the judge is going to be deciding what's proportional to the case. So again, it's to rein all of the parties in. One of the other things that I came across doing my research is Rule 26G, existing Rule 26G. Now, I always knew that signing a pleading was subject to Rule 11, Rule 11 sanctions. But I did not know under Rule 26G, by signing a request for production of documents or a response to a discovery request, either a discovery request, interrogatories, anything of that nature, you are certifying that the discovery is not interposed for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, and that neither unreasonable nor unduly burdensome or expensive, considering the needs of the case prior discovery in the case, the amount in controversy, and the importance of the issues at stake in the action. I've always overlooked that provision. I actually never knew it existed, but it's significant in the sense that if you're going to have very contentious litigation and a lot of discovery disputes, you can always turn to that provision and say, this person is not complying, this lawyer or this party is not complying with their discovery obligations in good faith. And believe it or not, it happens. A lot of I was telling Mr. Leisure that it's ironic I'm having this presentation today because very rarely do I have a discovery dispute in the Fort Myers community. Very, very rarely. It's very impressive when I serve a discovery request for a trustee that there's a timely response to it, there's good faith efforts to comply with it, and in those rare occasions, you know, I know it's not the lawyer that's on the other side that's responsible for causing disruption. It's in other jurisdictions like New York, it's, you know, like the wild, wild northeast. It's, you know, it can be out of control. And, you know, it can be very result in a lot of costly litigation. I'm going to turn now to the changes to Rule 34 of the Rules of Civil Procedure, which are also very, very significant. Before I do, I apologize. Before I do, I want to talk about another change to Rule 26. Protective orders. The provision on protective orders, Rule 26C1B, now adds that the court may order the allocation of expenses with regard to a discovery dispute. And it's very significant in the sense that if you're asking for, you know, reams of ESI or, you know, gigabytes, megabytes, terabytes of ESI, you know, and it becomes very, very costly for the responding party, that responding party could seek a protective order from the court and provide, I would suspect they would have to provide an estimate to the court of the cost of complying with that, and the court has the discretion to order the allocation of expenses to fulfill the response to the discovery request. And I guess at that point you would have the option of saying, well, I don't want to pay that much, Judge, so I'll withdraw the discovery request. I believe that's a very significant change as well. Another change in Rule 26 is early request for production of documents. Under the current rules, there's a moratorium at the beginning of the case on when discovery requests can be served. And there's also a moratorium under the current administrative order prescribing procedures for administrative proceedings. The administrative order and the current rules provide that discovery shall not commence until the meeting of the parties, the Rule 26F conference. Under the amended rule, you can deliver a request for production of documents to opposing counsel 21 days after the complaint is served on that party, or after the complaint is served. And the intent of that provision or that change is to allow for a more robust Rule 26F conference. So Mr. Leisure sues my client, 21 days go by after the complaint served, he serves a request for production of documents, or delivers, I'm sorry, very critical word is delivery. He delivers a request for production of documents to me. When we have our Rule 26F conference, I can see the type of documents that he's requesting and the scope of what he's looking for, and our conversation should be more productive if we have eyes on a document that is going to trigger discovery in the case. If we're not able to resolve any issues at that Rule 26F conference, as soon as it's over, it's considered served. So delivery, 21 days after the complaint served, Rule 26F conference concludes, it's considered served, and then the time period to respond commences at that point. Another change to Rule 26 relates to the 26F conference. Under 26F3, there's a change as it relates to electronically stored information. And the change talks about preservation of electronically stored information. So one of the subjects you are required to discuss during the Rule 26F conference is how electronically stored information will be preserved. That did not exist under, it does not exist under the current rule, but it became important enough that the rule was changed to address preservation of electronically stored information. I recently dealt with this issue, and I'm still dealing with this issue as it relates to litigation against a financial institution. And one of the discovery requests seeks electronic communications emails. The bank's email system has an auto-delete feature. So 90 days after an email is sent, it's deleted from the inbox, it's deleted from the sent items, and it's deleted from the deleted folder. So it's no longer on the main server. It then goes to these backup tapes. The litigation in which I'm involved is for 4 years, transfers 4 years before the bankruptcy. And trying to get emails 4 years ago when there's no, those emails have not been preserved becomes problematic. How do we deal with this issue? We deal with this issue if we're involved in pre-petition litigation with a party. We send a ESI hold letter to that party. And that they're then legally required to preserve their emails of certain custodians that are involved in the subject matter of the issues. I think in many bankruptcies you have creditors that are going after debtors pre-petition. You know, they may have sent a litigation hold or an ESI hold to the debtor or to some of the debtor's friends, relatives, etc. It's critically important, the preservation of electronically stored information, because of the massive amount of data it's gone. If you ever try to subpoena AOL, Yahoo, Google, you know, to get emails, good luck. I think they have a 30-day auto-deletion policy. So the sooner you can get your litigation hold letter out there, the better. If for some reason you can't do it until the litigation commences, it should be done promptly, and it should be a subject of the discussion in the Rule 26F conference. The other change in Rule 26F relates to 502 agreements under Federal Rules of Evidence 502 about clawing back inadvertently produced attorney-client privileged or work product communications. They're also required to be part of the 26F discovery plan. Now I'll turn to Rule 34. Rule 34 relates to request for production of documents. Many of us, in either responding to requests for production of documents or in receiving responses, we see these boilerplate objections that, you know, I'm not answering to the extent it's outside the scope of the rules of procedure, I'm not answering to the extent it's a public record, I'm not answering to the extent it's in the possession of a third party, you know, on and on and on and on, boilerplate objections. And then when there's a response to a specific request, it says, subject to the foregoing objections, I'm producing documents 1 through 10. Well, when you get that, did you know that you've gotten everything that's non-privileged and responsive to that request? You're scratching your head. What is going on here? You know, it causes tremendous confusion and unnecessary discovery practice. In the case I had in Virginia, the defendant responded to the discovery request by saying, we produced everything that was within a reasonable search, within a reasonable amount of time, and you know, that's what we're producing here today. So my response was, well, what's a reasonable search? What's a reasonable time? And have you really produced everything? They settled right before the hearing on the motion to compel. So that was a good result. I don't think the judge would have been very happy with them had they pressed those frivolous objections. The change to Rule 34 says that in responding to a request for production of documents, you need to either state that inspection and related activities will be permitted as requested, or state with specificity the grounds for objecting to the request, including the reasons. The boilerplate objections are out. If you need to meet each specific request with a specific response that actually applies, not this hypothetical, you know, general objection that is likely meaningless at the end of the day. The other change to Rule 34 that's significant is that the objection must state whether any responsive materials are being withheld and the reason they're being withheld. Again, that's significant in the situations where a party's, sort of riding the fence, if you will, on whether they produced everything. They need to, after December 1st, state whether they're withholding any documents and why they're withholding it. Additionally, which is quite significant, they need to say what their time frame is for producing documents. Read from this article. It says, the responding party may state that it will produce copies of documents and must state when the production will be completed. I know we've all been involved in cases where a responding party says, well, we're going to produce documents in waves, Judge. We're going to, just produce it in tranches over a period of time. Well, that doesn't work anymore. You can produce in waves, but you need to say when that last wave is going to come in. When first one's going to hit the shore and when the last one's going to come in, so that the parties can manage the case appropriately with a timetable of fact discovery deadlines, trial dates, and things of that nature. So that's an important change as well. Please bear with me for a second. Another change relates to the failure to preserve electronically stored information. The current rules talk about a failure to provide electronically stored information. This change is significant in the sense that it reverses an inconsistency that existed among the circuit courts of appeal regarding who was culpable for unavailable ESI or ESI that has an unexplained absence. Some circuits had a negligence standard that applied to missing ESI, meaning, Judge, I know I was sued by this party and I knew litigation was likely, but I sold my computer at a garage sale. That's, I'm not going to say stupid. It's not wise to do if you're involved in litigation. And that's a negligence standard. In some courts, not that example, but some courts adopted a negligence standard in cases where litigation was reasonably anticipated, but that ESI was not preserved, thereby prejudicing the other party's ability to prove its case or to prove its defenses. The rule now reads, if electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery, the court, upon finding prejudice to another party from loss of the information, may order measures no greater than necessary to cure the prejudice. So the court has wide discretion here. The court's looking at, should the ESI have been preserved? Was the ESI lost because a party failed to take reasonable steps to preserve it? Can the ESI be restored or replaced through additional discovery? The court's going to evaluate all of those factors. And now prejudice is going to be required as a precursor to any imposition of curative measures or potentially sanctions. If there's prejudice to a party, the court is going to try to craft these curative measures to alleviate the prejudice. And if there was an intentional act to deprive a party of the information, the court may, one, presume that the lost information was unfavorable to that party. So if I'm trying to prove that Mr. McHale fraudulently transferred a Bentley automobile to we'll say, Mr. Champeau, and some of the critical evidence in there about consideration is unavailable, then the court could assume that there is no consideration if there's no proof that is being produced, if there was an intentional effort to withhold that information, and the court makes all the findings of prejudice and whatnot. The court can also instruct the jury. We don't have a lot of jury trials in bankruptcy, but if there is a jury, it would instruct the jury that it may or must presume the information was unfavorable, or the court could dismiss the action and enter a default judgment. When I first read this rule, I thought the rule was intended to help parties seeking ESI. And I was surprised to learn that the rule was actually drafted with the perceived problem of over-preservation in mind. Apparently, in large corporations and even, I guess, in mid-sized corporations, they're keeping everything. I don't know what you call that, a pack rat, what is that the saying? A pack rat? Yeah, they're keeping everything, volumes and volumes of data, you know, because, you know, like some of us as lawyers and, you know, other professionals in the judicial system, we say, you never know when I need it, because, you know, the day I throw it away, there's going to be, I'm going to need it that day. So these companies were keeping all of this massive data because they were fearful that somebody would make a claim of spoliation or that they could potentially be sanctioned should there be litigation, and they would be unable to produce the documents. You laughed at my earlier chart. You won't laugh at this one. It's pretty corny, but it applies to this situation. It's a picture of looks like a husband looking at his wife as she's putting the computer into the freezer, and she just says, "But I don't want the data to spoliate." Like I said, it's corny. That, you know, just preserving the information is important, but you want to obviously not have to preserve too much and create significant expense and anxiety as a result of that. I want to turn back to the Rule 26 proportionality factors for a second and talk a little bit more about, you know, what could be within the scope of that, or how, you know, you all may have views on what is or is not proportional to an action. I know in representing trustees, we typically look at the creditor body. I mean, if there's a, you know, $5,000 credit card debt, are you really going to go after a $10 million fraudulent transfer? I mean, really, you know, you look at what the case justifies, and you determine what is appropriate, so it's proportional to the case. A practitioner in Tampa recently gave me an article, which I found very interesting. I don't know if people know Lynn Sherman. She's with the firm Adams and Reese in Tampa. And the title of the document is "A Longer Statute of Limitations Period for Pursuing Fraudulent Transfer Actions May Exist." It caught my attention. So, as we know in bankruptcy and fraudulent transfer claims, you have a 2-year look-back period under 548 to pursue avoidance claims. So you're not necessarily going to be seeking discovery for a 2-year look-back period if the transaction occurred 2 years ago. Under state law, under Chapter 726 of the Florida statute, you have a 4-year look-back period, which applies pursuant to 544B of the Bankruptcy Code. And again, you'll be looking for emails like I did for Mr. Leisure for 4-year period prior to the bankruptcy filing. 544B says that a trustee can step into the shoes of an unsecured creditor and pursue fraudulent transfer claims that unsecured creditor would have had under applicable law. Under this article, it talks about a 6-year statute of limitations that's potentially available under the Federal Debt Collection Procedures Act, and a 10-year look-back period under the Internal Revenue Code. And the case law that talks about this, and there have been many cases that have bought into this. I don't know if Judge Delano would. I'm afraid to, do something that aggressive. But, in these situations, for instance, you have a debtor that has primarily tax debt that is owed to the federal government. You got this Federal Debt Collection Procedures Act that allows the government to assert fraudulent transfers to collect that debt. The trustee steps into the shoes of the federal government and can potentially assert a fraudulent transfer claim going back 6 years prior to the petition date. Some courts have bought into that, as I said. I raise the issue in the sense of the discovery proportional to the action, proportional to the needs of the case. Now we're looking at discovery 6 years before the litigation began. Same thing under the Internal Revenue Code, but for the fact it's a 10-year look-back period. So we have those issues to deal with. With respect to the other situations where you have some questions about what's proportional, as I mentioned earlier, who is the defendant? Is the defendant an elderly individual, is a closely held corporation, is it a publicly traded corporation? You have the age of the defendant, you have the occupation of the defendant, you have various factors that will certainly be subject to analysis and certainly some case law in the future. The other thing I was scratching my head about when I was reading this is, what does it mean, proportional to the needs of the case? Are we now going to engage in analysis like is done with liquidated damages clause, where you say, well, if the liquidated damages are a small percentage of the total contract value, under 25% or whatever it is, then it's a valid liquidated damages clause. But if it exceeds that amount, it's a penalty that's unenforceable. Are we now going to do that in litigation, really? Are we going to say, well, it's a $1.2 million case, but they're saying that ESI production is going to be $120,000. It's not proportional. I don't think that's where it's going to go, but there are some very creative defendants. I don't mean to pick on them, but I usually represent plaintiffs. But a lot of creative defendants that will put up every roadblock into you getting access to the truth and being able to present your case fairly. With respect to responses to requests for production of documents, we've all encountered the situation where you serve a request for production of documents, they have 30 days to respond. They then move for a 30-day extension. 30 days, you get a response in the mail that comes, or email, I shouldn't say mail. You get a response via email. And in the response it says, I'll make the documents available for inspection. So there you'd sat 60 days waiting for the production to come in. And you get the response and it says, I'll make it available at reasonable business hours, mutually convenient times. It doesn't cut. It doesn't work that way anymore after December 1st. And I was at a seminar recently where somebody, probably represents defendants primarily, raised their hand and said, when I get a request for production of documents after December 1, I'm going to read it, and I'm going to determine whether it's proportional to the needs of the case. And if it's not, then I'll send the response, and then I'll make the documents available later on. And then the question came up, well, did you even bother to look at the documents that were potentially responsive to the request for production? You can't make an objection based upon proportionality or it being improportional to the needs of the case if you haven't even looked at the documents. They potentially could be sitting in your client's office or near the client's office. It could be available. So the courts are not going to look upon you with any favor if you are raising objections that, while legally appropriate, are not factually supported. There's likely going to be need for estimates from these discovery vendors, D4 or other discovery vendors that are out there to support your argument that it's not a proportional discovery request and that there's an undue burden or expense. So the rules have been completely revamped. I encourage you all to review them. I have lots of materials. If you email me, I'm happy to provide any of the many PowerPoint presentations I have on the subject matter. Many articles, scholarly articles about it. But I feel very confident that it will allow for the litigation process to be more expeditious, less costly, and will certainly result in these cases moving forward more quickly. So thank you for your time. Appreciate it. Oh, I'm sorry, one more thing, may I? May I? One of the items on the agenda was publicly available resources, and I wanted to refer you all to the Middle District Discovery Handbook. This is on the website for the U.S. District Court for the Middle District of Florida. It is fabulous. It was revised in June of this year, subsequent to the date that the Rules Committee, the Supreme Court transmitted the rule amendments to Congress. So it likely includes some pertinent, timely information. I know it's oftentimes cited to judges, bankruptcy judges in the Middle District of Florida, although it doesn't technically bind them or apply. It's highly persuasive. So I encourage you all to download that and familiarize yourselves with that. The other resource that's out there that I was made aware of in a case by somebody else was the Federal Judicial Center. The Federal Judicial Center is a website that exists, an organization that exists primarily for federal judges. And they publish numerous publications ranging from confidentiality orders or agreements, protective orders, ESI, and a publication that I came across which is fabulous is Managing Discovery of Electronic Information, a Pocket Guide for Judges. So if you know what a judge's view on a topic that's going to come before him or her, it's certainly helpful. In fact, after I graduated law school, my mom gave me a little paperweight for my desk, and it said, a good lawyer knows the law, a great lawyer knows the judge. And, you know, when I first got that, I thought it meant you had to have a personal relationship with the judge. But obviously, it's important to know what the judge's likes and dislikes are, which way a judge is leaning on an issue. So I encourage you to go to the Federal Judicial Center website and look at those publications. The last one is the Sedona Conference. The Sedona Conference is a organization with a lot of judges, practitioners, academics, and they publish incredible items that are pertinent to the practice on a day-to-day basis, including a document called Preparing for Your Rule 26F Conference. So I encourage you all to make use of those publicly available resources. And again, thank you very much for the privilege of presenting to you today.
Hey Bob, I really appreciate it. Again, just want to remind you the next meeting's December 17th. Gwen Hutto of Reed and Kelly is going to bring you some goodies, some homemade sweets, so you don't want to miss those. I don't know if you've ever had them before. She does an excellent job. So we'll see you on December 17th, and don't forget also mark February 25th next year for Judge Williams. Thank you.
Thank you. Yeah. I wish I had cases where I had discovery at all.